Before I go into describing the process, I want to start this video with some information about Marty Weinberg. Because really, he's the one with all the experience. He's the one presenting the habeas petition. And you'll need to have some faith because he's very damn good at it. He's one of America's top appellate advocates. He's practiced as a chief trial and appellate counsel in hundreds of cases for more than 40 years. He's represented multitudes of accused defendants in over 20 federal district courts, 8 US courts of appeal, and in the US Supreme Court. If you want to talk about decorated dudes, look no further than Marty G. Weinberg. He not only knows all of the circuit courts back to front, but he's also won some landmark constitutional cases. So let's give the guy some credit, because all I am is a researcher poking around in the dark. With that said, let's talk about how the process works, and by understanding that, we can kind of work out where the habeas petition is at. So this will be a continuation of my previous video, to which I will put the link in the description, where I described a 5-stage process and where I think we're at in that 5 stages. To add something to your petition after you've filed it, you do have to have it all in place before the scheduling orders are issued by the court. So if we have a look on the court website, we can see that the scheduling orders have been issued. They were issued on the same day. And that's because Chief Judge F. Dennis Saylor expedited the order, understanding how critical it was given the coming date for the second trial. After scheduling orders have been issued, you would need to ask for leave of the court in order to amend your petition if you want to add things to it. But as I have discussed in previous videos, it's not necessarily required for you to make specific requests of the federal court, because they are going to read the transcripts and everything involved anyway. They may well see exactly what we're seeing without being directed to. I'll give you an example. In one of the attachments to the main document, i.e. the petition, the Commonwealth itself submitted its own brief to the SJC, and on around page 20 of that brief, they actually went into quite some detail about this jury foreperson's apparent bias. Of course, they weren't presenting it as bias, but you would hope that the federal judges know their stuff and would at least raise an eyebrow as to why this juror was so blatantly pro-prosecution, where all the other jurors appeared to be more balanced, not taking one side or the other, while at the same time being very concerned that their votes were not communicated to the judge. And again, you would also hope that the federal judges would also look at why didn't their votes make it to the judge. This is probably the line of questioning that you might expect during the March 5th hearing. Like, what was the process that prevented the partial acquittal on 2 counts from reaching the judge's ears? The reason I'm confident that the federal judges will probably look into it is because we pulled mountains of federal case law that supports the proposition that the federal courts are well aware of all of the issues that we raised. So anyway, back to amending your original petition. You have up until scheduling. If you miss that deadline, you can ask for leave of the court to amend your petition up until that first hearing on March the 5th. But if the judges start asking questions during that hearing about the processes that went into selecting the jury foreman and who was writing the notes to the judge, who was being the communicator between the jurors and the judge, etc., then you'll be given other opportunities to enter more information for the federal judges to consider. That wouldn't necessarily be an amendment to your petition, but providing the information that the federal judges are asking for. And so in that manner, you may find that one question leads to another question, which leads to another question, and before you know it, the whole gamut of violations are laid bare, without you, the petitioner, having to specifically raise them at all. So all these things that I've just mentioned in the last couple of minutes boil down to strategy. And let's consider strategy a little bit more closely. because it doesn't just boil down to when's the cut-off dates to be able to amend your petition and add all your cumulative errors, etc. There's a couple of things that might play into your strategy. The first being, we already know that the current petition is around 300 pages. That's including the SJC ruling and any of the trial transcripts that are relevant to that ruling and so on. So if we were going to add my last 6 videos of cumulative error to the filing, we'd be increasing the file size exponentially. And an exponentially larger case before the federal court doesn't lend itself to expediency. If one of your strategies is to emphasize that your petition needs to be expedited so that it can be seen and heard before Trial 2.0, then keeping your brief to a single point may well be your best strategy. But there's also other things to consider, like what's the long game? For example, if this petition fails and you're forced to go back to trial, do you want to burn all your bridges now, or do you want to wait for more cumulative error to mount up throughout the second trial so that you at least have a bigger mountain of due process violations with which to overturn, in the worst case scenario, a conviction? Considering very carefully that a mistrial is not a worst case scenario, but a conviction is, then you don't want to burn all your bridges before you even get to Trial 2.0. Just because you could relate all of these cumulative due process claims to your original petition doesn't mean you should. If you don't make these claims now in this petition, you're free to make them later in a separate petition. It does make perfectly good sense not to tie the due process violations to a common core of operative facts in the original petition. The fact that the courts are probably going to require a separate petition anyway, then yeah, this strategy makes perfectly good sense. And it leaves you with a backup plan if, in the worst case scenario, you end up with a conviction. So no matter what your strategy is, how do you go about introducing cumulative error? What is the cumulative error doctrine? This is a legal principle that holds that multiple errors in a trial, even if individually harmless, can collectively result in an unfair trial and violate due process. Then the combined effect of errors deprives the defendant of a fair trial, and the conviction may be overturned or habeas relief granted. The legal basis for the cumulative error doctrine falls under Supreme Court precedent. In Taylor v. Kentucky, 1978, a trial tainted by multiple small errors can be unconstitutional if their cumulative effect renders the trial fundamentally unfair. Chambers v. Mississippi, 1973. Even if no single error alone rises to the level of a due process violation, their combined effect can. Parley v. Runnels, 2007. If cumulative errors have a substantial and injurious effect on the trial's outcome, habeas relief is warranted. United States v. Rivera, 1990. The cumulative error analysis considers whether errors interacted to influence the jury's verdict. The legal standard for cumulative error: courts assess whether the combined effect of multiple error created an unfair trial. Even if each error is individually harmless, their synergistic impact can violate due process. A defendant is entitled to a fair trial, not a perfect trial, but if multiple errors prevent fundamental fairness, relief is necessary. When does cumulative error apply? It applies when there are multiple legal errors in the trial process, and each error alone is not necessarily enough to warrant relief, but their combined impact undermines trial fairness, and when the errors interact in a way that prejudices the defendant. For example, improper judicial rulings, plus prosecutorial misconduct, plus jury misconduct. Cumulative error does not apply when there was only one legal error, the errors were minor and did not affect the outcome of the trial, or the errors were unrelated and did not compound each other. For example, individually, an incorrect jury instruction and an improper evidentiary ruling might not be reversible errors. However, if both errors combined to confuse the jury and lead to an unjust conviction, cumulative error applies. How the courts analyse cumulative error. Step 1, they would identify each error. Was there prosecutorial misconduct? Did the judge improperly influence the jury? Were there evidentiary errors? Step 2, determine whether errors had a combined effect. Did the errors reinforce one another in a way that disadvantaged the defendant? Were the errors strategically used to favour the prosecution? And step 3, assess the overall fairness of the trial. Did the trial remain fundamentally fair despite the errors? Did the errors influence the jury's verdict in a material way? In federal habeas cases, cumulative error can be a basis for relief if the errors had a substantial and injurious effect on the verdict. The key habeas cases that support this would be Kyles v. Whitley 1995, the suppression of multiple pieces of exculpatory evidence required cumulative error review. Alcala v. Woodford 2003, multiple prosecutorial errors resulted in a fundamentally unfair trial. And United States v. Wallace 1988. Habeas relief was granted because errors, though harmless alone, had a prejudicial combined effect. Why the cumulative error doctrine matters. It matters because it recognises that multiple trial errors, even if individually minor, can create an unfair trial when combined. The key takeaways are, even small errors can violate due process when combined. Habeas relief is available if cumulative errors had a substantial impact on the trial's fairness. Courts assess whether errors reinforced each other and influenced the verdict. What this tells us is that cumulative error on its own can be a completely separate petition, argued on completely separate grounds. Like, for example, if something else goes wrong with jury 2.0 and you end up with 2 compromised juries, that would be the perfect scenario. So let's talk about the pros and cons of amending the current habeas petition or waiting until after trial 2.0 and filing a new petition. So let's start with the advantages of amending the current petition. Firstly, it would allow the federal court to evaluate all due process violations in one petition. Secondly, if trial 2.0 is delayed or stayed due to habeas intervention, including cumulative error claims, now strengthens the argument. 3. It prevents procedural objections later that the claims were waived by not raising them earlier. And 4. If relief is granted on cumulative grounds now, it may eliminate the need for trial 2.0. We talked about that in yesterday's video. It's a very real outcome that the federal court could dismiss with prejudice all 3 of the charges. So what are the disadvantages of doing it now? Firstly, it might implicate or delay the habeas process, requiring the court to analyse more claims before ruling, or as I said, exponentially increasing the size of the case. Secondly, the federal court may reject the argument if it believes the cumulative errors should be assessed post-trial 2.0. And thirdly, you may be able to present an even stronger cumulative error claim after a second trial if further violations occur. What are the pros and cons of waiting until after trial 2.0? The advantages of waiting would be, firstly, if additional violations occur in trial 2.0, they can be included in future habeas petition for a stronger cumulative error claim. Secondly, the second trial may provide even more evidence of judicial bias, prosecutorial misconduct, or other due process violations. Given the last few days of rulings, that's looking very real. And thirdly, it keeps the current habeas petition focused on the key claims already accepted, preventing delay or dilution of stronger individual claims. The disadvantages of waiting may be if trial 2.0 results in another conviction, the defence will need to start a new round of appeals and habeas filings. Secondly, the current habeas petition could be denied without considering cumulative error, missing an opportunity for immediate relief. And thirdly, if the second trial is flawed but not overturned on direct appeal, waiting could extend the overall litigation time significantly. And for Karen, that's probably going to be a major cost factor as well. So, would the best strategy be using a hybrid approach? For example, if you believe the cumulative errors from trial 1 alone are strong enough, then maybe you'd consider amending the habeas petition to include them now. However, if you expect more due process violations in trial 2.0, which I think we are already seeing, then you would document everything and be prepared to file a stronger cumulative error claim afterwards. But the other consideration is that if trial 2.0 is prevented or delayed due to the first habeas petition, then adding cumulative error now could strengthen that case for an outright dismissal. It may well be smarter to monitor the federal court's response to the pending habeas petition to gauge the best timing for adding cumulative error claims. And if I had to guess, I would say that is probably, not possibly, but probably what Marty Weinberg is doing. At the end of the day, he's not guessing anything. He knows how this works, but I am. So let's put our faith where it rightly belongs, with Karen Reid's very experienced appellate lawyer, Marty Weinberg.